Who keeps the original will on Long Island, New York? In the course of our lives, it is essential to plan ahead for our loved ones' financial and emotional well-being when we are no longer around. Creating a will is a vital part of this planning, as it provides clear instructions on how to distribute our assets and handle other matters after our passing. However, having a will is not enough. It is equally important to store the original copy in a safe and secure location. This article explores the significance of a will, its key components, and the various options available for storing it on Long Island, New York. It also outlines the factors to consider when choosing a storage method and the process of retrieving the original will after the testator's death. Importance of a will. A will is an essential legal document that outlines how an individual's assets and properties will be distributed upon their death. Especially in this age of financial uncertainty, the importance of having a will cannot be overstated. Definition and purpose of a will. A will, also known as a testament, is a legal document that expresses an individual's wishes as to how their estate should be distributed after their death. It also appoints an executor to administer the estate and carry out the directives stated in the will. The main purpose of a will is to ensure that the deceased's assets are managed and distributed according to their wishes in the most efficient and accurate way possible. Key components of a will. According to New York statute, it is mandatory for the testator to be a minimum of 18 years old and possess a state of sound mind and memory. Typically, a will must be created in a physical format, specifically on paper. Moreover, to create a legally binding will, certain requirements must be met. While it is advisable to consult with an attorney for specific details and local requirements, the following components are generally necessary. Execution of a will. Witnesses. Declaration. Benefits of having a will. Creating a will has numerous benefits for both the individual and their loved ones. Some of the most notable advantages include: take control of the distribution of your assets after your passing by creating a personalized will. Empower yourself to choose a trusted executor who will handle your estate affairs and asset management when you're no longer around. Prioritize the protection and care of your minor children by appointing a guardian through your will. Maintain the flexibility to modify your will while you're in good health. Experience a profound peace of mind for both yourself and your family by having a well-thought-out plan in place. Necessity of storing the original will. A will is a crucial legal document that outlines the distribution of a person's assets and estate after their death. Proper storage of the original will is essential to ensure that the testator's wishes are respected and executed accordingly. Difference between original and photocopies. The original will is the actual document that was signed and dated by the testator in the presence of witnessing parties. The original document carries more significant legal weight and is predominantly required when the court is asked to approve the will as valid, a process known as probate. Photocopies, on the other hand, are exact reproductions of the original document made by a copying machine. They typically do not have the same legal weight and may not be sufficient evidence of a testator's intentions in probate proceedings.
Legal requirements for presenting the original will.
When a person dies, the probate court evaluates their will to authenticate it and confirm that it abides by the legal requirements. The original will is usually required in this process, and failure to produce it may lead to significant delays, increased expenses, and potential disputes among beneficiaries. Challenges due to lost or damaged original will. Losing or damaging the original will can result in several challenges during the probate process, including delays, increased costs, and potential disputes among beneficiaries. Some of the issues that may arise due to a lost or damaged original will include presumption of revocation, burden of proof, disputes among beneficiaries, options to store original will on Long Island. Creating a will is an essential step in estate planning. However, the existence of a will is of little value if it cannot be located after the testator's death. Properly storing the will is crucial to ensure that the testator's assets and possessions are distributed according to their wishes. There are several options for storing an original will, and each has its advantages and drawbacks. This article discusses 4 common storage options on Long Island, New York: at home, in a safe deposit box at a bank, with an attorney, and at New York Surrogate's Court. At home. Some people may choose to store their will at home, which can be convenient but also fraught with risks. A fireproof, waterproof safe should be used to protect the document from damage, theft, or accidents. Burglary, fire, or natural disasters could result in damage or loss of the will. Moreover, the will's location should be communicated to a trusted family member, executor, or friend to prevent it from being misplaced or overlooked. Safe deposit box at a bank. Safe deposit boxes at banks are commonly used for securing valuable documents, including wills. These boxes offer greater security than storing at home, protecting the will from theft, fire, and other disasters. They also provide a level of confidentiality since only authorized individuals can access the box. Entrusting to an attorney. Entrusting the will to an attorney offers several benefits, including convenience, security, and professional management. An attorney who has drafted the will is often the best choice for this option since they are already familiar with the testator's estate plan. Attorneys are typically required to maintain a safe and secure location for storing clients' original documents, thereby ensuring the will's protection. Additionally, assigning the attorney as the executor of the estate can streamline the probate process. New York Surrogate's Court. Another option specific to New York State is the Surrogate's Court filing system. The Surrogate's Court is responsible for overseeing the probate process, making it an appropriate institution for storing original wills. For a one-time fee, the court will store the will in a secure location, providing both protection and accessibility. The court will also issue a receipt for the will, which should be kept in a safe place as it serves as proof of the will's existence.
Retrieve the original will after a testator's death.
Retrieving the original will after a testator's death is an essential part of initiating the probate process. The executor, an attorney, or a storage facility may be responsible for locating and preserving the will, depending on where it was kept. Here, we will discuss the process and responsibilities of each party and further steps required for administering the testator's estate. Process for executors. As an executor of an estate, it is crucial to locate and access the original will as promptly as possible. This task typically involves the following steps:
Finding and accessing the original will.
Submitting the will to the surrogate's court. Probate process. If you would like to explore how we can assist you with your will, get in touch with us at 516-574-9630 to arrange a complimentary consultation.